with the Massachusetts Attorney General's office about new regulations applicable to junk fees and auto renewals. I'm going to give it about 30 seconds just to make sure everybody can get into the webinar, and then we will get started. So stay tuned. Thanks, everybody. All right, well, I think we can go ahead and get started. Hi again, everybody. I am Paul Singer. I am a partner and chair of our state attorney general practice here at Kelley Drye, and welcome to our webinar for today, which is a discussion with the Massachusetts Attorney General's office about their new regulations that are applicable to junk fees and auto renewals. I am grateful to be joined by my colleagues in our state AG practice, Abby Stempson and Beth Chun, who have been on all of these webinars with us in the past, and then our special guest today, Yael Shavit, who is the chief of the Consumer Protection Division in the Massachusetts AG's office. Really appreciate you taking the time today to talk to us, and especially about these regulations, which I know are top of mind for a number of our clients. Before we get into our agenda for today, just a couple of housekeeping things I wanted to go over. First, if you are seeking CLE for today's presentation, there will be a CLE form that will be provided after this presentation. On that form, you'll see a space for a 4-digit CLE code. I will provide that code at some point during today's presentation. I'll read it out twice, so please make sure to jot it down once I read out that code. Second, if you have any questions, we welcome them. We've got a lot of content to get through today, and so I'm not guaranteeing we'll be able to get to all the questions that we receive. But in the event that there are some leftover questions, as many of you may be familiar with, we follow up today's webinar with a blog post, and we will make sure to address any outstanding issues in that post, as well as summarizing what we talk about today. So with that, I think we can go to the next slide and talk about just a real brief overcap of our agenda for today. Those that are familiar with our AG webinar series know we do a brief lightning round, like we like to call it, where we are really digging into Consumer Protection Authority in the particular state. And then we're going to spend most of our time today talking about the new regulations applicable to junk fees and auto renewals. So with that, I'm going to turn it over to Abby to kick us off on our lightning round.
Good afternoon, everybody. Yael, so happy to have you here. Yes, and what we do love to do is go through this lightning round to not only show you the similarities between some of the state laws, but also the major differences that occur between the UDAPs and Consumer Protection Acts between the states. So let's get started.
All right.
The AG selected in your state?
Our AG is elected.
Wonderful. And when is she up for election next?
Real soon, next year.
Okay, next year. And for our listeners, what's your AG's name?
I'm Drye Campbell.
Okay, wonderful. So tell us about how consumer is organized in your office, Yael, because this is where things definitely get really different between the states.
Absolutely, and there are a lot of differences. In Massachusetts, we have 2 expressly consumer-facing divisions. We've got my division, which is the Consumer Protection Division. We are an enforcement division. Our goal is to enforce our consumer protection laws. Chief among them are UDAP statute, Chapter 93A. But there's a completely separate division, which is called the Consumer Advocacy and Response Division. We lovingly call them CARD. And they work one-on-one with consumers who submit complaints to our office to try and help work with the companies that might be the subjects of those complaints to reach a resolution. And we work closely, our 2 divisions do work closely. We can see the trends and the complaints that they receive, and that helps inform our work, but we are distinct divisions. And then in addition to that, we have a community outreach division, and they work closely with us and certainly with CARD to help do consumer education and know your rights type of information that our office tries to put out to assist consumers and businesses in understanding the law.
So Yael, between those two big divisions, do you know approximately how many people you have in your office that work on consumer?
I'm not sure exactly, and I don't want to state it incorrectly, but it's certainly north of 40.
Okay. So consumer protection priorities, as our listeners probably know, consumer laws can apply to pretty much anything when it comes to business activities. How do you set your priorities?
Sure. So one of the Attorney General's core strategic priorities generally for our office is ensuring economic opportunity and consumer justice for everyone in the Commonwealth. And that goal helps inform our consumer protection priorities. But we get information in a lot of different ways with respect to the types of issues that we should consider tackling. We hear from residents directly, as I mentioned, through complaints that people file that get addressed by our card division. That's one way that we can hear what's actually happening on the ground. We're also in close touch with other enforcement partners and hear about what they're experiencing. We get outreach from organizations in the Commonwealth that may share observations that they have, and we follow trends that are reported on. And in addition to that, we're also all consumers. So we observe as well what we're seeing as trends in the economy that can help inform our work.
I think we might have a little technical difficulty there. So Yael, I don't know if you can kind of go back about seconds.
Sure. I was just saying there are a lot of different ways. And can you hear me now?
Yes. Everybody else, can you?
Yes.
All good?
Okay, great. There are just so many ways that we hear about consumer protection issues that it overwhelmed the streaming. So there are a lot of ways that we hear about it. We hear about it from consumers directly, from other organizations that reach out, from our enforcement partners, and just by experiencing the trends that are happening in the economy as consumers ourselves.
So let's go to our next question, and it's, do you participate in multi-state investigations? But maybe before you answer that, give the one sentence, what is a multi-state consumer investigation?
Sure. Multi-state investigations are really what they sound like when multiple states work in a coordinated fashion on a mutual investigation. I guess that can take there are different ways that they can go about doing that, but at core, it's really coordination. And the answer to the question, do we participate in them? Yes, we do. I think they can be very efficient, both for the states and frankly for the entities that are under investigation, to keep things organized and efficient for everyone.
And so you did talk about consumer complaints a bit and your consumer complaint resolution role. Do you want to add anything to that?
No, I guess just encouragement. If there are folks who are observing this, who either themselves or work with other individuals who raise consumer concerns, that we really do want to hear about it. And it's easy to get to our consumer complaint link. It's right on the AGO's homepage. I think it just says submit consumer complaint or submit consumer form. And it's a really quick form. And I really consistently try to say that it's helpful for two reasons. One, so that we can try and help people. And the other, because as I mentioned, it's one of the most important ways that we hear about what people are experiencing in the Commonwealth. So it's also just valuable for our office to understand what's happening and what people are experiencing.
Okay. And you've already mentioned 93. Do you want to talk a little bit more about your primary consumer protection statute?
Sure. It is a statute of broad applicability. It generally makes it unlawful to engage in unfair and deceptive acts or practices in trade or commerce. And the courts have consistently understood the statute to be one that was designed to be broadly applicable and to apply today to business models that may not have even existed at the time that the law went into effect. So it is one of the stronger consumer protection statutes in the Commonwealth. And there are a couple of sort of interesting things about it. I'm preempting some of the questions on the slide, so I'll stop myself. But there are three things I'll flag about it. One, it gives our office investigatory powers that are very strong. Two, it also creates a private right of action, which is not true for all states' UDAP statutes. And three, it gives our office regulatory authority, which foreshadows what we're going to be talking about for most of our time together today, because the regulations at issue were promulgated by our office under 93A.
And you mentioned investigations. Can you conduct pre-suit investigations under your UDAP?
Yes. So under 93A, the Attorney General has the authority to initiate investigations when she has reason to believe that someone is either engaging in or is about to engage in violations of 93A. So that is actually very broad investigatory power.
Can you request documents?
Yes, we can request documents, and we can also take testimony under oath.
Okay. Interrogatories?
We do not get interrogatories.
How about CIDs, or civil investigative demands? Are they confidential, like the actual CID that you send out?
The CID itself is not strictly confidential, though it's our practice generally not to disclose that a CID has been sent out. But again, the next half of that question I think is important to folks. The information that we receive is protected under Section 6 of 93A, so that prohibits disclosure of information that's produced pursuant to the CID without the consent of the person who produced it or a court order. And one important exception to that is that we can disclose that information in court pleadings and other papers.
How about if a party wants to object to a CID or move to set it aside? Can you do that?
Yeah, so parties can object, and in a world where we're not able to reach a resolution through that process, the recipients can seek a court order if they think that they have a good reason not to comply with the CID.
And what kind of time frame does that have to occur in?
It's not explicit within the statute, but generally speaking, it's typically a 30-day time period.
How about compliance? How do you then enforce if someone doesn't want to respond?
We can petition the court for an order to enforce the CID.
And how about a statute of limitations? As you know, some states don't have any, some states have 4 years, some have 2. What do we have in Massachusetts?
The second one there, we have a 4-year statute.
4-year? Okay.
4-year.
Do you have to provide pre-suit notice?
We do. We have to send out what we call a 5-day letter, which is, as you would expect, 5 days notice before we commence the lawsuit. The goal of which is to facilitate a last-ditched effort at resolution pre-litigation.
Great. So we have a few more questions for you. I'm going to turn it over to Paul, who's going to continue with those questions. Thank you.
Thanks, Abby. So let's turn to resolution of a consumer protection case. Can you tell us what kind of settlements you can enter into?
So under 93A expressly, we can enter into an assurance of discontinuance where an investigation has resulted in us finding violations of law. And that's expressly under 93A. But of course, if we end up filing a lawsuit, then that is typically going to be a consent judgment.
And what about civil penalties? What is your civil penalty authority under the statute?
We can seek penalties of up to $5,000 per violation.
And I know it's not on the screen, but are violations defined, like what that means? How do you count violations?
No, not for purposes of figuring out what that 5,000 applies to.
Yeah, which is something we like to remind people, and it's actually a very common thing across many consumer protection statutes. What about restitution or disgorgement? Can you obtain those under your act?
Yes, under the act, we can explicitly, it explicitly calls for restitution, and there's case law that also indicates that we can get disgorgement.
So knowing that you have these injunctive remedies and monetary remedies, are there times where you may prioritize one over the other, or you might not get injunctive relief or might not get penalties or a payment in a resolution?
Sure. And I mean, anytime we go into a CID investigation, we have a number of goals. If we have in fact identified misconduct, 2 of the bigger ones are ensuring that people are made whole, and that's where restitution comes in. And that ends up being a pretty significant requirement of ours for purposes of settlement. But similarly, it's really important for us to make sure that the misconduct doesn't continue and that we stop it. And so it is very typical for us to seek injunctive relief, either to prioritize it in the context of settlement, or when we're engaged in litigation to seek injunctions in addition to the damages or monetary relief that we're seeking. So it would be, I think, a fairly rare occurrence for us not to prioritize injunctive relief.
And so once you have that injunctive relief, how do you enforce those terms? And especially, what if they're in an assurance versus a consent judgment?
So evidence of a violation of one of our assurances under 93A constitutes evidence of 93A violations. So in the event that we believe someone is not complying with an AOD, we would, of course, initially try and see what's happening there. We wouldn't run into a courtroom immediately, but we can, and it would be as a 93A action.
So turning to some other areas, more narrowly applying in the consumer protection space, do you have a specific law or regulation about price gouging?
We do, and it's a regulation. It's 940 CMR 3.18, and those regulations prohibit price gouging with respect to any goods or services that are necessary for the health, safety, or welfare of the public during statewide or national emergencies. And in addition to that, those same regs cover the sale of petroleum products in the context of a market emergency.
Yeah, and I would just flag this. I know it's not the topic for today, but one reminder we like to tell people is price gouging regulations and laws they do vary on a lot of different respects across states, both when they're triggered, what the penalties are, what the thresholds are to determine gouging, what products are covered. All of that is something that varies from state to state. So last question, and this might be the most obvious segue question that we could have come up with, but do you have any new noteworthy consumer protection laws that have been introduced recently?
Why, yes, we do, Paul. Our junk fee regulations were, as I mentioned before, promulgated under 93A. They're economy-wide regs. I think they're a pretty big deal. And they went into effect on September 2nd, so they are still quite fresh.
No, and that is such a great segue to our next topic that we're going to jump into, and I'm going to hand it off to Beth in just a second. I will say that obviously, I would say just broadly across the country, junk fees, auto renewals have been a very hot topic. I think we're seeing a lot of states start to pay very particular attention, and I certainly appreciate that we're going to do a deeper dive into the Massachusetts regs and talk about implications for businesses. I do think it's important to note and that everything we talked about just on the general applicability of your UDAP law is going to carry into some of this too, right? Historically, states have been looking at the existence of fees or unexpected charges, and in particular auto renewals, just from a general consumer protection, unfair deceptive trade practice theory. But I think we're seeing a lot more specificity now as some of these laws and regulations get put into place. And so hopefully that will help everybody, both regulators and the business community, find sort of a path to clarity as to what expectations are. So Beth, I will hand it off to you to kind of tee up our discussion on the new regs.
Yeah, thanks so much. So I know Paul just talked some about how this is a growing landscape, and I think that's going to be some of the approach of where some of my questions for you come from today, is some of the similarities and differences with your new regulation compared to some of the few existing other fee-related laws that are emerging throughout different states. But I think it would be really helpful if you could start things off for us with a high-level overview of the regulations before I dive into the specific questions.
Absolutely. So as I mentioned, these regulations were promulgated under the Attorney General's regulatory authority in our UDAP statute in 93A. And before I jump into the actual details of the regs themselves, I wanted to provide a little context by discussing the process by which they were promulgated. So we first published our proposed regulations, the draft regulations, on November 30th, 2023. We held a public hearing and got nearly 100 comments from a variety of industry groups and organizations and Massachusetts consumers. We reviewed every comment that we received, and then in March of this past year, we published our final junk fee regulations. So throughout this process, we also understood that while our regulations will typically go into effect the day they're finalized, that with these regulations, businesses would need a little time to go into compliance. So we provided a 6-month window from the publication of the regs to the day that they became enforceable, which was on September 2nd. And so the regs have 2 main components. We call them our junk fee regs, but it's really our junk fee regs and our negative option regs. The first, which is under 940 CMR 38.04, that's our total price rule. It makes clear that drip pricing, which is a phenomenon by which only part of a product's total price is actually advertised, and mandatory fees don't appear until closer to the end of the transaction. So it mandates that drip pricing basically is unfair and deceptive and prohibited by 93A. The second component, which is in section 38.05, covers negative option contracts. And it provides clarity on what a business needs to do when it offers consumers trial offers, subscriptions, and similar types of auto-renewing contracts that keep charging you basically until you do something affirmative to stop that from happening. At core, these regulations, both sets of them, are designed to put more information in the hands of consumers. They are critically not a ban on any products or on any fees. So you can continue to buy subscriptions. A business can continue to charge fees. The regulations simply make clear what we would, I really think, all expect, that when sellers advertise a product, they need to tell you up front what the total price of that product is going to be. And when businesses sell subscription products, they should give you clear notice about what you're signing up for, and canceling that subscription should really be as easy as signing up for it was in the first place. To provide a little context on the scope, these are economy-wide regulations that cover any business that sells, leases, or rents products to consumers in Massachusetts. The only industries that aren't covered by the full regulations are airlines. That's a matter of preemption. But the regulations do recognize that there are some industries that already have statutory and regulatory frameworks that provide relevant protections to consumers. And so both the regs themselves and our guidance document explain that for those specific industries, compliance with their existing statutory and regulatory requirements will be treated as compliance with our new regulations. I should take one more step back, though, and mention for a minute really what junk fees are, because the term junk fees can cover a variety of practices that sellers might use that have the effect of hiding the true price of a product. So it includes the drip pricing that I mentioned before, but this would also include certain bait and switch pricing and the imposition of really any poorly disclosed fees that would increase what you would expect the final cost of the product to be. So a few examples I give is if you've ever paid a convenience fee and wondered what the convenience fee was actually paying for, that may be an example of a junk fee. If you've ever made a purchase online and discovered that when you get to the final checkout price, the price is actually like double or more what you thought it was going to be when you saw it in your shopping cart, you also in that instance may have paid junk fees. And that's why we've issued these regulations. Moving on to the negative option side, and I'm really almost done with my kind of opening framework here, but on the negative option side, negative option contracts are really just those contracts that renew automatically without any action being taken by the consumer. Most subscriptions that we have, including things like gym memberships or streaming media, are negative option contracts because they renew automatically without any input from the consumer. Our regulations require companies to give consumers the information they need to make informed decisions about subscriptions and trial offers. And they do so in a couple of ways. First, they require sellers to provide consumers with regular notice about their subscriptions. And second, they require sellers to provide consumers with a simple mechanism to cancel a negative option contract. And what that means is that they need to give users a method of canceling that is at least as easy to access and use as the method that consumers use to sign up for the product in the first place. So the regulations prevent situations where you can sign up for a service basically with like 2 clicks of your mouse, but then it takes, you know, 2 self-addressed stamped envelopes that need to be sent to a very specific PO box halfway across the country at a certain time to cancel. And again, the detail, there are a lot more details here, right? And those details about the timing and the requirements of the disclosures and the notices are all in the reg text and are explained in the guidance. And I do want to make a plug for the guidance, which is linked on this PowerPoint as well. The guidance stemmed out of many industry conversations that we had both before we promulgated the regs and after the regs were finalized, where we heard some kind of repeated FAQ type questions for folks or areas where they thought they needed more clarity. We really endeavored to answer those questions in this document. So I really do want to encourage folks not only to look at the reg text, but also the guidance document. And that's it.
Great, thanks so much. And I wanted to give a plug too to the fact that you guys also do have your own webinar also on this topic, a short version, and it covers a lot of the guidance information too. So I found that to be another helpful, digestible thing to see. So, and I have to admit, some of the questions we're going to go over were cribbed a little bit from the guidance document since they are so helpful. And I think part of what I wanted to talk about is because they are questions that I know that I've heard before, and that I think would be especially helpful to cover. And then some things, like I said, were inspired more by the fact that we have this for fees, where the patchwork is emerging right now, I guess I would say. With the automatic renewal laws, it's been growing steadily for the past few years. But with both, we have these similarities and differences between each other that does sometimes make compliance a challenge for businesses, even when they're trying to do the right thing by consumers, just because of some of the practical difficulties with these things. So I really appreciate you giving us the opportunity to have a conversation about some of these questions. So to start out with, I think with you mentioned that there's different types of fees that could be added to a charge, and whether or not we agree on whether they're junk fees or not. We have this requirement in the statute in the regulation that says 38.04 parentheses 2 prohibits misrepresenting or failing to disclose clearly and conspicuously at the time of the initial presentation of the total price of the product, the nature, purpose, and amount of any fees. Essentially, it goes on a little bit. And I think one of the things that when I first read that, it made me wonder if the fees themselves needed to be disclosed at that initial offer point separately from the total price, or if they don't need to if they're already in the total price. So I guess if that's something you can expand on, that was really helpful when I read the guidance on that one.
Yeah, absolutely. And let me actually start by answering something that's not exactly what you asked, because similar to the question you asked about, do the fees actually need to get disclosed? We also get questions about whether or not any particular fees are banned. And I think sometimes the answers sort of go together. So I will emphasize that the regulations don't ban any particular fees. What we require is that the price you see is the advertised total price. And so there's a lot of seller choice and preference that goes into what actually needs to be displayed and how it's displayed. So critically, if a seller is making the choice to break down their price of a product and show a particular portion of the product's cost as a fee, they're permitted to do that, but they are not required to. If sellers would instead prefer to present the price of a product as one all-in price and not list any fees separately at all, they're absolutely still permitted to do that. as long as doing that is sort of consistent with other statutory and regulatory requirements, right? So I'm sure there are other laws that mandate that certain fees be broken out. You obviously need to comply with those laws, but this regulation doesn't require that any particular fee be broken out. It's just saying if you, the seller, are choosing to display a particular part of the price separately as a fee, then in that case, the total price needs to be the most prominent price displayed, and any fees or expenses that you're choosing to list out need to be fairly and accurately described, which goes back to the requirement of displaying the nature, purpose, and amount of the fee.
So if you, if at that initial offer point, you have wrapped up all the fees into the total price, but then later at the checkout, there's a breaking out of certain fees at that point, would the position be that the nature and the purpose of the fees is just disclosed at the checkout, or would that need to also be at the initial offer stage too? Like,
it's at the offer stage too. So if you are making the choice to break out particular fees, you need to do that when you're displaying the price initially as well. So
even if the initial price is an all-in price.
Right.
Okay.
And there is some language in the guidance as well, and I'm going to paraphrase it incorrectly, so I just suggest that folks take a look at it, that talks a little bit, that gives a little bit of context about what it means to actually discuss the nature and purpose and how that can actually be demonstrated, because we did get some questions about what that actually requires. And in fact, I'm happy to go into that a little bit more if that would be helpful right now.
Yeah, that sounds good.
Sure. So, the requirement is that of this nature and purpose language is to tell the consumers basically an accurate representation of what the purpose is that the sellers are using the money that's being collected as that fee or charge for. And many of those fees could be disclosed just using a really concise phrase, right? Like in the hospitality context, I can think of like a cleaning fee if you're renting a hotel room or an apartment or something like that, provided that the amount charged is actually reasonably reflective of the cost that the seller is incurring for the cleaning. And there may be instances where a consumer might require more, an ordinary consumer might require more information to understand the nature and purpose of a fee. And there, sellers can use concise language combined with a commercially reasonable and accessible means of providing the additional information. So, for example, if we're talking about like an electronic advertisement, having a concise phrase that's coupled with an information button or a link to more information if it's necessary to provide that context, that's appropriate, and that's spelled out in our guidance document.
So this actually might be a good point to show the little picture we have on the next slide that comes from the guidance document.
Sure.
And I don't know if you want to kick us off on what makes these different disclosures compliant and non-compliant.
Sure. So maybe the best way to do that is to just say a few more words on what total price means, right? So total price is the maximum price that a consumer must pay for a product. And so just to like walk through this for a second, and the mandatory nature is important, right? It's like what you actually need to pay. So we tried hard with this quadrant here. If you look at the left side, an example actually of related to the question you asked, do you need to roll it in?
Yes.
Or are you allowed to roll it in? Do you need to disclose it? So on the left, the top and bottom are both completely compliant, right? In the top example where it just has the total price, that's an example of a seller saying, you know what? I don't want to disclose any particular fee. I don't want to break anything out. I want to just give one all-in price and like make it simple. That's it. That's an example there. And that's true even if, let's say, it included a cleaning fee. You don't need to tell the consumer that if you don't want to. If you do tell them, you need to do it accurately and clearly. But here, total price all in. Beneath it, this is an example where the seller is making a decision that they do want to disclose that a portion of that total price is going for something specific. And here you can see that example. So you see the total price number is still the most prominent, and underneath it, you have a description that of the nature and purpose of this fee. So they're saying this price, the total price, includes a $5 surcharge to cover the cost of processing an online transaction. So they want you to know this is how much it costs to do that. That's reflected in the price you're paying. So now let's look for a second at the non-compliant disclosures. So the top one you'll see is a price of $5 less than that total price next to it. And that's because it does not include all of the fees. There might be a notice there that says the seller is going to add a surcharge, a $5 surcharge to cover the cost of processing, maybe at the end of the transaction, but our regulations mandate that that $5 be put into the total price that a consumer sees most prominently when any price is displayed. So that's why that's not compliant. And then the last example, the one on the bottom right, it does have the $5 baked in. So the total price number is accurate, but it doesn't tell you anything about the nature and purpose of the $5. It displays the fact that there is a fee, but it doesn't talk to you about the nature and purpose. It just says that there's a $5 surcharge included, but it doesn't tell you what it's being included for. And so that's what makes that particular one non-compliant.
I really appreciate it. I think that, so returning back to my hypothetical again, now that we have this in front of us and you've talked more about it too, you were mentioning if the total price, the one on the top left, $148.86. If it includes a cleaning fee, you don't have to disclose that to consumers. But if in this hypothetical at the checkout there was a cleaning fee, and the total is still $148.86, then would the position be that would then require the disclosure similar to the bottom left, or is it okay to not include that description until the checkout?
Right. So what 38.04 mandates is, or what it states is a violation of 93A, is to fail to disclose a few things at the time of the initial presentation. So at the time of the initial presentation, or at any subsequent presentation of a price, you need to disclose the total price of that product. And then as well, at the time of the initial presentation of the total price of any product, you need to disclose the nature and purpose and amount of any fees, charges, or other expenses that would be imposed on the transaction due to the purchase of that product. So if you are choosing to to tell consumers at any point that you are including a fee, if you're going to do it at the end, you need to do it at the beginning, and you need to disclose the nature and purpose there.
It's super helpful to understand because yeah, I think, like we talked about before, we don't have all the context when we're looking at this picture. And so I really am glad I've got to pick your brain on this today. So thank you so much.
And I do want to say, just because I've been using shorthand a little bit, and obviously I encourage anyone for whom these are actually going to apply to actually look closely at the regulatory text. But we do exclude shipping charges and government charges, both of which are defined terms in the regulations from that disclosure initially, right? So if there's a shipping charge or a government charge, that doesn't need to be baked into the first presentation of the total price. And there as well, I know that those definitions can differ from regulation to regulation. Like, I mean, from one state's junk to another state.
That's a great point.
So I do also really encourage people to go and look at the defined terms and make sure that you understand what's included and what's not.
Yeah, and I will say that, like, as far as talking about the similarities and differences, that concept is pretty similar to what's in most of the state specific fee statutes, is that there's an exclusion from the total price for government imposed taxes and things like that, and for shipping. But yeah, you're definitely right that there are nuances in both of those parts and the different in the different state laws. And so that is definitely important to understand, especially if you have an edge case with your business on one of those things. And also what you were mentioning before, the definition of total price is the maximum price a consumer must pay for a product. And so I think it's helpful to understand that if there are different options available for a consumer that they don't necessarily have to pay, how do the regulations address that? And that's another area where things kind of differ from state to state, or maybe more ambiguous.
And let me just pause to apologize for the very strange lighting on my face, because it has suddenly become a very sunny day in Boston, and there's nothing I can do about it. So to go back to the more important point, fees that depend on optional consumer behavior. Let me actually talk about two natures of sort of optional consumer behavior: the stuff that happens after you do a purchase, and the stuff that happened before you complete the purchase. And we'll start with the sort of more straightforward, is what if it happens after you've completed a purchase. So let's say that there's a fee that depends on behavior that happens after a purchase. For example, a fee that you might incur if you break a bunch of stuff in a hotel room. Those are not mandatory, and they don't need to be included in the total price. So the total price doesn't need to build in the possible eventuality that you're going to cause damage to a space. Similarly, and I think a little bit like, I'll talk about this in a little more detail, if the issuance of a fee or charge depends on choices the consumer makes prior to or during the transaction, the seller does not need to include that fee in the total price that it displays prior to the choice being made. So for instance, just to stick with a simple example, with a hotel example, when you're booking a hotel room, consumers may have a bunch of different optional features that they can select from that may affect the final amount of the payment. And the hotel can advertise, for instance, if they choose to, the room's lowest available price as the total price, so long as consumers are actually able to book at that advertised room at that price, and that the pricing information is not otherwise misleading. But once a consumer selects a feature that increases that price, the seller needs to update the total price to reflect the choice, right? So for instance, if initially the assumption was that you were going to get a room with, one queen bed, and then a consumer at some point in the process says, no, actually, I want a king bed, the price would then need to be changed to reflect those choices that the consumer was making. And there may also be fees or charges that aren't presented as mandatory, but where the seller's failure to actually include them in the total price would be deceptive. And I just want to say that. So sellers, need to include in the total price all fees or charges that meet certain conditions, again, other than the government charges and shipping charges. So if it's a fee that consumers can't actually reasonably avoid, like a credit card processing fee, if there's no other viable method of payment, or a fee that's like really basically built in because the seller may use a practice like, default billing or pre-checked boxes or opt-out provisions. So a seller can't treat as optional, I think this is a core piece, can't treat as optional, and therefore needs to include in the total price a fee that's going to be charged to you automatically and can only be removed if you happen to notice it and take some kind of action to specifically remove the fee yourself. So that's one piece I'd add. And then just the other piece that I'd say is that a fee that a consumer needs to incur in order to actually make whatever they're buying work, to make the underlying good or service fit for its actual intended purpose, and which you would expect to be part of that purpose, is not an optional fee. And the example that we gave in the guidance is one that I'll just repeat here, which is, for instance, if a hotel is requiring a guest to pay for the use of towels in a hotel room, that needs to be included in the total price. The consumer would reasonably expect that if they're staying in a hotel room, they're not going to need to pay extra to be able to use a towel. That was a lot, but I hope that was helpful.
No, definitely was very helpful. Thank you.
So I wanted to jump in first, I've stayed at some hotels that probably you wouldn't reasonably expect to have towels, but so I mean I will say that. But no, I want to go to the nature and purpose of the fee for a minute, and Yael, please, if you're not prepared to answer this, that's fine.
Sure.
But this slide I think kind of highlights something to me, which is I'm sure you've seen a lot of different sellers come up with different names for fees over the years, and there's different ways that you can characterize a fee. It strikes me that like where is the line, and what happens when someone wants to call something fairly generic, like this is just a processing fee, or I know we have like a non-compliant one here that says it's just a surcharge. But sort of understanding this balance between wanting to keep sort of the description relatively simple versus how much information we need to provide to explain what that fee is. And then similarly, is there any guidance or anything y'all have looked at in terms of how you evaluate that fee is reasonably tied to the costs associated with that description, right? So like this example of the cost of processing your online transaction, I'm just kind of curious, like what would you look at to determine whether $5 is a reasonable amount to cover the cost of processing an online transaction in that kind of instance?
So a couple of things. I mean, I think part of the challenge here is that it's hard to answer that question in the abstract, right? Because I think a lot is actually going to depend on the specific details. And I'm aware that I chose a fairly easy example as the one that I highlighted. But I think if you look to the purpose of the regs, right, which is transparency and disclosure, and allowing people to understand what they're paying for and how much they're going to need to pay for it, that I think should be sort of the guiding light. And of course, I should take a step back by saying that I can't offer legal advice, and folks should definitely consult with an attorney if you have a question about whether or not you think what you're doing is in compliance. But I think the real question to ask is the explanation that I'm giving enough for an ordinary consumer to be able to understand what the point of this fee is, what it's being used for? And in terms of the amount of money, that the fee represents, again, we are not banning any particular fee, right? So the goal of these regs isn't to sort of cast a judgment or create an avenue for casting a judgment on how much someone is, for instance, charging for actually cleaning a room. But it goes back to the transparency and disclosure goal here. If you are making an affirmative choice as a seller to represent to the consumer that a certain portion of the price they're paying is going for a specific purpose, right? You must have a reason why you think the consumer is going to want to know that information. If you're choosing to tell them, hey, this is what this is going towards, that needs to be true, right? And it can't be that, you call something a fee that you think might be a palatable thing to a consumer and actually just use that as, it all goes for the exact same purpose, but you've said, hey, this is the fee for such and such.
Yeah.
So again, it doesn't, I think that in terms of what someone might look for looking into this, it's whether or not it's actually tethered to what you said you were going to use the money for.
Yeah, and I mean that this is helpful because, I think the way we view it is, one, it's a reminder that, these regs are not just about transparency about the total price. It's also about transparency about what these additional charges are for, right? That's an important piece. But then I think once you're making those kinds of affirmative representations, those same principles of deception apply that have always applied, right? You can't tell people that a charge is for one thing when it's really for something else.
Yeah, and you know what, Paul, I think you just said something important that I do want to highlight. There's a lot in here that, quite frankly, was a 93A violation before, was clearly a 93A violation even before this. So even though now there are particular disclosure requirements about when you have to say things and like, what is the most prominent price that's displayed, this piece of it to me, if you're telling someone that they're paying for something and that's not actually what they're paying for, that is a bread and butter deception claim, right? That is a misrepresentation. It was a misrepresentation before September 2nd as well. And so that is sort of a good thing to think about. These live these regulations live in the existing framework of the misrepresentation and deception law in the state of Massachusetts, in the Commonwealth, which has always had very strong consumer protection laws around these types of issues. So that is a good mindset to have in thinking about how these apply in the context of the rest of the regulatory framework.
And adding to that, it would be a misrepresentation in every other state as well, right? I mean, that's kind of, because again, that goes back to sort of the point I was trying to make earlier of that, you know, these regulations are being done in the context of broader UDAP authority that states have relied on in looking at fees and auto renewals in the past. And so it's just important to keep all of that in mind as you're trying to come into compliance.
Sure.
Okay, so I think it's also helpful when we're talking about what disclosures are required to understand too when is providing the total price actually required, and like whether there's any affirmative requirements for when a business has to advertise with a price or with a total price specifically. And so if a business was to advertise a like % off sale or, you know, $20 off sale, are they then affirmatively required under the regulation to display the total price with those type of offers if there's no other pricing information provided? I think that's helpful to hear.
Right. So because the regulations prohibit advertising a price that's less than what a consumer is actually going to have to pay for the good or service, an advertisement that might mention a discount or, you know, certain percentage off, but doesn't actually include a price, does not violate the regulations. And so that's sort of like a long way of saying, like, yes, a business is permitted to advertise a discount without providing a total price if it's otherwise allowed by law. And I do want to make that last statement because I know that there are other regulations that may obligate sellers in sort of like the truthful, non-misleading advertising context to say a price in certain contexts. And this doesn't change anything about that. But if it's otherwise permitted by law, you can just say there's a discount, there's a certain % off without needing to say the total price.
Appreciate that. One of the interesting things I found about the Massachusetts regulation was, I think y'all are the only ones who have specified that the total price must be disclosed specifically before requiring a consumer to provide any personal information, including billing information. Are you able to share any of your thoughts on what other information could be considered personal information under that requirement, or elaborate on kind of the thought process at all?
Sure, I'll give some, absolutely. I'll give some examples, but I think maybe the thought process is a helpful thing to share here. And I'm not sure if I've shared it in other contexts, but really, you know, what you see when you're looking, especially like online transactions, is that where you're hit with a price at the end only after you've spent a lot of time putting in your personal information. Maybe it's like your geographic location, your name, your phone number, your entire address, all of your credit card information, your email address. The longer a transaction is taking, the more you're saying, the harder it is to escape that transaction or to click away and say, you know, actually, no, thank you. When, you know, 15 minutes later, you see a price and it's not the price that you were expecting. And so that's the one that, that's sort of the motivation here, to make sure that before people are doing a lot of like buy-in to the transaction, they know what to expect so that they're not stunned at the end, but then, you know, still feel like they need to go through and complete the transaction. So those examples I gave in the middle would be examples here, and I don't have other good ones at my fingertips.
Thanks. Appreciate that. Since we are running short on time, I want to make sure we get to talk some about auto renewals.
Sure.
And I think briefly, if you could talk for a minute about how these two concepts interplay, just because I think that it wasn't immediately obvious to me why these two were together. Of course, they're both really important topics, but I appreciated seeing some in the guidance of how these two might intersect.
Yeah. So the junk fee regulations were designed to increase price transparency, right? And to ensure that people know what they're paying for and how much they're going to need to pay. The auto renewal sections also promote similar transparency by ensuring that people understand under what circumstances they're going to need to make a payment and what they would need to do to cancel the contracts and avoid future payment obligations. So I kind of think of them as like going through the trajectory of the life cycle of the purchase, right? Like what you're experiencing at the front end when you're making the payment you're signing up to begin with, and then for those that sort of continue with continuing payment obligations, the second half of the regs address the transparency necessary for those types of products.
Yeah, that makes a lot of sense. Thank you. And as we're talking about sort of the life cycle of the product and sort of the consumer flow, a lot of auto renewal laws contain some similar concepts to what are in your regulation, including concepts of initial disclosures, cancellation requirements, notice requirements. But I think one of the things that I saw there that struck me as a little bit different from what I've seen in other state automatic renewal laws was that there are certain places where Massachusetts has a requirement to provide disclosure of a calendar date specifically. So there's a section where it talks about trial offers, providing a calendar date where the customer must reject or cancel the offer before paying, or in the reminder notice, there's a concept of providing a calendar date by which the consumer must cancel. Is this an area where you all have heard logistical or practical difficulties with complying with this from businesses, or is that something that you consider in compliance with this requirement?
So just to take one step back, and I will actually answer the question, but providing consumers with a calendar dates, or to say kind of why in these contexts, we view as necessary to make sure that they actually have the information they need to actually avoid the unwanted payment and to take the steps that they need to cancel a product they may not want. And in the absence of the actual specific calendar date, it's much harder for the consumer to navigate the cancellation process. And of course, this is the date that is calculable for the business, right? And it actually will be calculated, right? Because if that's the date on which you're going to get charged for a trial offer, the business knows that. They just need to give the same information to consumers that they have. And also, for companies that are offering auto renewals that are longer than a month, those are the ones where they would, for auto renewals that aren't trial offers, those are the ones that would need to offer to tell you the specific calendar date. They're really best positioned to know the date by which they need to receive the cancellation request to actually be able to prevent the billing for the following month. That's what the purpose is of the calendar date in that context. And that's knowable for them, right? And it's not something we're dictating. We're not saying you need to make sure that they can cancel within 12 hours. We're not dictating that, but we're saying the date by which you need to get it to make sure that they don't get billed. That's the date you need to tell them so that they can make the right choices for them based on that information. So the specific question, we haven't seen any evidence to suggest that complying with that requirement and ensuring that consumers have the same information about their obligations that the businesses charging them have would be onerous or impracticable for businesses.
Appreciate your perspective on that, since that's, like I said, something that we don't see in all of the state laws. Something just really quickly at the end here, we were talking about the notice requirements. Again, this is an area where I see something different with the Massachusetts regulation than with other state laws that require reminder, what we like to call reminder notices. You all have this two different separate reminder notice requirements, one for contracts with terms over a month, and another concept for contracts with monthly or less renewing terms, and different requirements for each of those. The one for monthly or less renewing terms, there must be a disclosure at least as frequently as the consumer is charged, is what I've read here. And I thought it was really helpful to articulate in the guidance what that means for what kind of notice that a business must provide, because that type of monthly notice is something that, like I said, I don't know that I've seen in most other state laws.
Sure. So the motivation for that monthly requirement is twofold. It's both to ensure that consumers get the notice that they need on the one hand, while also doing it in a way that would be workable for businesses. And that's the reason that we specified and really actually have tried through this process to emphasize that if a seller is already providing consumers with like a bill or an invoice or a receipt or really any other form of notice that would itself be compliant with the requirement in 38.056, that they don't need to do an additional notice or generate an additional notice to give to consumers. And for that reason, I think many companies may already be providing compliant notices in their ordinary course of business. And for others that need to shift things, I will say, you asked about what we're seeing. It's too early. It's because they've only been in effect for about a month. It's too early for me to be able to discuss, compliance trends. But I do think that just based on conversations, I think that some businesses may choose to adapt their existing notices, their bills, their invoices or whatnot, to include the required information such that they would still only be sending out what they were previously sending out, but they've adapted that somewhat to cover the disclosure requirements of our regs. And there will, of course, be businesses that may need to make new notices to comply with the regulations. But I think that many businesses that are already sending out communications will adapt those communications to bring them into compliance.
Thanks so much. I know we've run over time, Paul, and we got to read that CLE code for people.
We do, and I know we've hit time, and obviously there's a lot more we could have discussed, and I just really appreciate Yael, you really getting into the weeds here and yes, really sort of walking through a lot of this. We greatly appreciate it, but I do think it's somewhat symbolic and indicative of your office's willingness to engage with the business community generally on a lot of these questions and issues as they arise. And so I certainly, on behalf of our clients, can express our appreciation for that. So definitely thank you for everything that you shared today. As Beth mentioned, I do have the CLE code to read out. It is 3289. That code, one more time, is 3289. As I mentioned at the start, you'll put that code in the CLE form that will be circulated around to you. And just a general thank you to all of my co-presenters today, but also everyone that attended and listened to today's discussion. We'd encourage you to subscribe to our AG Chronicles newsletter. This is a monthly newsletter that we put out where we pull together various AG related news throughout the country. And then more generally, you can use our link tree to find all sorts of consumer protection, ad law, privacy law, updates, issues, trends, anything like that. As we mentioned at the beginning as well, we will follow up today's webinar with a blog post and summarize a lot of this discussion. And, to the extent you have additional questions or need some additional guidance, please don't hesitate to reach out to us because we're always happy to help. So with that, I will wrap it up and just say another thank you to everybody.
Thank you all for having me.